Hello Manaswi. Here is the patent search report indicating relevant patents granted or in pipeline which are close to your invention. We have looked at the patent databases of many countries such as India, USA, Europe and Japan. In our opinion, it is a good case for patenting.
That's great.
Rajat, can you please explain the procedure adopted by you?
Sure. See, there are various search strategies. I identified all the relevant International Patent Classification (IPC) codes likely to be associated with the invention. Then a search was made in all the databases mentioned above. Similarly, the patents of all the competitors were also searched. Besides, we also conducted a keyword search on claims. Based on these three searches, a list of relevant patents was compiled and the claims of these patents were compared with your invention.
Strategy for prior art search. Shortlisting keywords. Exhaustive search of databases. Classification search. Analysis and interpretation of search results. Stress on identifying the prior art not only related to the invention, but which may have a relevance on various other aspects of the invention.
That is quite an effort. Shiraz, have a look at it and discuss with Rajat. Let me know if it is satisfactory.
Okay.
Dinesh, I understand that we can get a lot of useful information from patent documents. How does it help in business decisions?
Very good question. The available information can be used for different purposes. Have a look. Using patent information. Prior art. Patentability analysis. Infringement analysis. Technical information. Legal information. Prospective competitors. Validity search. Technology forecasting. Unattended areas of research. Citation analysis for patents.
How does a company like InvoStat benefit from prior art search?
Prior art or state-of-the-art search helps you in identifying the broad areas of research and development. State-of-the-art search provides a broad overview of defined technical field as it covers all or broad range of patent and non-patent literature relating to it. Reveals relevant published papers, studies, other non-patent literature, patents both expired and unexpired, as well as published patent applications worldwide. Mainly used for establishing the starting point and direction of new research and development projects. Advantages of prior art search. Understand what similar ideas have been publicly disclosed. What is needed to design around. Refine and improve the invention. Save time and effort in writing futile patent applications. Clear focus on areas where exact R&D efforts are needed. Besides, it also helps to understand the market, avoid patent infringement, learn more about the field of the invention.
I presume we should have done it before embarking upon the development.
Definitely, that would have been a good strategy.
What is the advantage of patentability analysis?
I have already explained to you the need for carrying out the patentability analysis. Let us recapitulate. Patentability search. It is narrower in scope than a state-of-the-art search. It is done with reference to a defined field of technology, such as that contained in an invention disclosure, for identifying relevant prior art, for evaluating the novelty and/or non-obviousness of the disclosed invention. The results of a patentability search are very useful for drafting stronger or better patent claims and may also reveal potential conflicts with patents owed by others and or the possibilities for getting around them. A patentability search is done while preparing and before filing a patent application. It helps the applicant to decide whether or not 1. To file a patent application, or 2. To proceed with the patent application as drafted, or 3. To undertake further research and development to make further improvements to the invention for getting a stronger patent.
Would patent information help me if I would like to introduce a new product in the market?
Very much so. It is always advisable to determine if your product would violate or infringe some patent in the market of your interest. If so, one should not introduce such a product in those markets. Infringement search, also known as a right to use or freedom to operate or clearance search. It is done to determine if any unexpired or in-force patents would be infringed by launching a product on the market or by otherwise practicing the invention in question. By this search, a party is cleared to make, use, sell, or import a product incorporating the invention. It involves a study of all the claims of all the relevant patents which are still in force to determine their scope of protection so as to avoid doing anything which will be considered to be an infringement of an unexpired patent. For accessing potential infringement, it would be necessary to study the claims of all relevant published patent applications too. Thus, periodically conducting a search at the stage of technical development, product development, or before marketing a product will enable a company to identify related patents and to ascertain their legal status in time to prevent an infringement.
It is very important from business angle.
No doubt about that. One can derive legal information from the databases. It is possible to determine the chain of ownership of a patent, which would be a common phenomenon when patents are assigned. It is important in patent and technology licensing. One can also know whether a patent is still in force or not. In addition, you must remember that claims of a patent also constitute legal information.
I can see that we can also get information on what our competitors are doing.
Correct. By looking at patents of interest or patents granted in your area of interest, you can easily prepare a list of the companies who are in the same business and monitor their patent portfolio. This information would also be useful in merger and acquisition. Sometimes you may like to find out whether patents have been granted to your competitors correctly or not, and then you will engage in a validity search. Have a look. Validity search. It is conducted after a patent is granted to assess whether the patent was properly granted. It looks for any publication, prior art, that can be used to prove that one or more claims of the patent are invalid. Validity searches are done because of 1. Current or anticipated litigation, 2. In the context of licensing negotiation, and 3. As part of due diligence for accessing the value of a patent. To challenge the validity of a patent, you have to search for patent or other document that could challenge its novelty or inventive step and uncover issued patents or other published prior art that may render such a patent partially or completely invalid. Thus, a validity search can be useful as a defensive tool when a company is concerned about infringing a particular patent.